Good morning. My name is Stephen Chiodini. I'm an attorney at Adler & Colvin in San Francisco, and I'll be presenting this morning's talk on the use of limited liability companies in fiscal sponsorship, or Model L, as Greg Colvin and I termed it in an article from a couple of years ago where we first explored the concept. So, why would you ever use an LLC in fiscal sponsorship? The LLC is, after all, usually thought of as a vehicle for doing for-profit business. With fiscal sponsorship, however, we found that setting up an LLC with the fiscal sponsor as the sole member can combine the advantages of the two current predominant models of fiscal sponsorship, Model A and Model C, while avoiding some of their pitfalls. Before delving into Model L, though, it's useful to review the attributes of Models A and C, as well as their relative advantages and disadvantages, since this is really how we started to perceive the value of the new Model L in fiscal sponsorship, and it also helps to bring the features of Model L into relief. Of these two primary existing models of fiscal sponsorship, Model A is the more straightforward one. In a Model A sponsorship, an outside project basically approaches the public charity that will serve as the fiscal sponsor. The charity agrees to set up a restricted fund on its books in which it will take in contributions and grants for the charitable purposes of the project. It may bring the key project personnel onto its staff. It may also form an advisory committee of project leaders to oversee the project. The key attribute of Model A is that the fiscally sponsored project is no different from any other internal program of the sponsor or any other activity that the sponsor carries on directly. And here we have a basic overview of how a Model A fiscal sponsorship works, which, as you can see, is really quite simple. Funders and contributors write their checks directly to the public charity that serves as the fiscal sponsor. The project is basically an internal program of the sponsor, which provides administrative services for the project as it would for any other internal program. The fiscal sponsorship agreement with project leaders can provide for their oversight of the project as an advisory committee. Model A is not without its drawbacks, however. Since the project is legally no different from any other activity the sponsor carries on directly as an internal program, the sponsor in principle has unlimited liability for project activities. This can be scary for a sponsor if project leaders want to pursue an activity with a high degree of risk, such as anything involving children. One more drawback is the fact that it can be complicated to spin off a project to a new sponsor. When you go to transfer a Model A project, you're essentially talking about transferring an internal department. This involves not only transferring funds, but also possibly assigning contracts and moving employees, which can become time-consuming and expensive. Yet one more drawback is the status of the project committee. Since the project is an internal program of the sponsor, it can sometimes become difficult to put your finger on exactly what legal role the project committee performs, not to mention what legal rights it has vis-a-vis the sponsor, and close care needs to be taken in drafting the fiscal sponsorship agreement here. Model C is quite different from Model A. Under Model C, the project remains external to the sponsor. The project is conducted by outside individuals or by an outside entity, even a new nonprofit corporation that hasn't obtained its exemption yet. The sponsor and the project enter into a pre-approved grant relationship, where the sponsor reviews the prospective grantee, determines that the grantee is able to carry out the project it's proposing, and commits to take in funds for the charitable purposes of the project and makes disbursements to the grantee. And here in slide 7, we have an illustration of Model C, with the project now located outside the sponsor, and the sponsor making periodic disbursements to the grantee and perhaps performing some back-office services. Note, however, that the fiscal sponsor itself is still the one taking the money in from grantors and contributors, and this can cause some cognitive dissonance for the project leaders and for the funders, especially since the project here is more autonomous than in Model A. One advantage of Model C over Model A is the sponsor's limited liability. It generally has the same level of liability as an ordinary grantor. Also, it's easier to spin off a Model C project, whether to another fiscal sponsor or, say, to a new nonprofit corporation that has been running the project as the Model C grantee and has just received its 501c3 exemption. This makes Model C especially useful for incubating charities. Third, it's easier to conceive of the Model C relationship in legal terms. There are two separate parties entering into a contractual arrangement. Model C also has its own disadvantages, however. As Greg's book explains, if there's a trap for the unwary among fiscal sponsorship arrangements, Model C is it. It can be very tricky to set up the model in a way that properly preserves the sponsor's discretion and control over project funds and avoids earmarking contributions for the project grantee. Also, the sponsor naturally has less control over an outside project grantee than it would over an internal Model A project. There can also be administrative difficulties, and in the background there's the question of how the grantee should be reporting the funds it receives. As I mentioned above, the model can also lead to confusion among funders, since a Model C project is more independent and autonomous by nature, and there's usually a real entity with the project's name that's running the project. Model L is quite a different thing entirely. Here, the sponsor operates the project out of an LLC in which the sponsor is the sole member. The sponsor controls the LLC, but since LLCs can be run by managers instead of by the member itself, the sponsor can install the project personnel as a board of managers with fiduciary duties owed to the sponsor. An LLC, of course, combines the limited liability of a corporation under state law with pass-through treatment for federal income tax purposes. A single-member LLC is disregarded as separate from its sole member for federal tax purposes, and its income and activities are treated as those of the sole member. Here in slide 12, we have diagrams of the three models side by side, and the thing you should immediately recognize is that in Model L, the outside funders are interacting directly with the project entity, whereas in the Model A and Model C structures, they're writing checks to the fiscal sponsor. This diagram also illustrates the relative autonomy of the Model L project. Although the sponsor is the sole member and has ultimate control over the LLC, the Model L project is separate and, at least in this diagram, is run by the project leaders as the LLC managers. Two critical developments made LLCs really a viable option for use in fiscal sponsorship under this sort of structure. First, in Information Letter 2010-52, the IRS clarified that where a private foundation makes a grant to a disregarded LLC whose sole member is a public charity, the foundation can generally treat the grant as a qualifying distribution and won't need to conduct expenditure responsibility. Second, in Notice 2012-52, the IRS explained that contributions made to these LLCs are eligible for a charitable deduction. With a Model L fiscal sponsorship, the activities and income of the LLC are attributed directly to the fiscal sponsor charity itself. The project is treated as an internal division of the sponsor, as would be the case with the Model A project. Differently from Models A and C, however, the funders and contributors cultivated by the project leaders can make grants and contributions directly to the project LLC. One caveat here: when we say federal tax treatment of LLCs, we're generally talking about federal income tax. If the LLC itself will have its own employees, the LLC will not be disregarded for federal employment tax purposes. For federal income tax purposes, Model L is a lot more like Model A. For state corporate law purposes, however, it's much more like Model C in that the project is conducted from an entity outside the fiscal sponsor. In Model L, the sponsor-project relationship is much closer, as their parent and subsidiary, rather than grantor and grantee. In principle, the fiscal sponsor has limited liability for project activities. I say in principle because, as we know, the veil of limited liability is not impermeable. Moving now to the mechanics of how Model L works, we envisioned that there were few ways to duplicate what a fiscal sponsorship agreement would otherwise do in a Model A or Model C arrangement, where the agreement would not only define the structure of the arrangement, but also spell out the sponsorship fees, the services to be provided to the project by the sponsor, and so forth. In the LLC context, the operating agreement would set up a manager structure, spell out the duties owed by the managers to the sole member, provide for periodic reporting to the member, and even address how a transfer of the membership interest to a new fiscal sponsor would be approached. One important issue is how to pay the sponsorship fee to the parent. In Models A or C, funding would be received from the outside by the sponsor itself, and the sponsor would then pay itself the agreed-upon fee out of the project fund. Model L is a little more tricky, and there are several ways to approach the issue. One of the more straightforward approaches, we think, is to have an administrative services agreement or a resource sharing agreement between the project LLC and the sponsor that provides for the payment of a fee to the sponsor and a reimbursement of the project's pro rata expenses. As I mentioned at the very beginning, Model L combines many of the qualities of Model A and Model C while avoiding some of their pitfalls. Compared to Model A, a chief advantage of the Model L arrangement is that the sponsor in principle has limited liability. Moreover, depending on where the LLC is formed, the project itself can also be somewhat protected from the sponsor's own creditors, since in some states the creditor of an LLC member can get at the member's economic interest in the LLC, such as its right to receive distributions, but can't get the actual membership interest itself, meaning in theory that a creditor can't vote the interest or cause the LLC to dissolve and distribute its assets upstream as it would be able to do in a corporate setting. This very much depends on where the LLC was formed, however, as well as where the parent and the LLC find itself in court. From the perspective of project leaders, Model L has other advantages over Model A. For example, if project leaders are installed as the LLC's managers, they'll have more practical control over the project's money, perhaps to a greater extent than would be the case even with Model C. It's easier to transfer the project than in Model A. The fiscal sponsor just assigns its LLC membership interest to a new sponsor. Also, the project has a fundamentally separate identity from the sponsor and can go out and solicit funding in its own name. Turning to slide 19, with a contrast against Model C, the project leaders in a Model L will typically run the project on a day-to-day basis, but the fiscal sponsor has complete legal control over the LLC. As its sole member, the sponsor can remove the managers, amend the operating agreement, or dissolve the LLC entirely. In a Model C arrangement, the sponsor holds the project purse strings, and it can stop the funding stream, but it would generally have no direct legal control over the grantee itself. Furthermore, in Model L, there's not really a need to worry about how the project LLC should be treating its income for tax purposes, since the LLC is disregarded as separate from the sponsor. Also, there should be less of a concern about vendor confusion. In Model C projects, a fiscal sponsor can sometimes find itself paying project vendors directly out of the restricted fund, with the sponsor's name on the check, whereas in a Model L project, the LLC just pays its own bills directly from its own bank account, with the funding it receives directly from grantors and contributors. There are, of course, a number of caveats with Model L. The first thing is the issue of startup costs. The LLC needs to be formed, and the operating agreement needs to be worked out, possibly with an administrative services agreement as well. Also, as I mentioned, the corporate veil between the parent sponsor and the project LLC is not impermeable, and the parties need to be careful about setting things up and running the LLC in a way that doesn't turn it into the alter ego of the sponsor. Conversely, because of the autonomy that Model L permits, combined with the fact that the LLC is disregarded as separate from the sponsor for federal tax purposes, the sponsor needs to be vigilant in monitoring the activity of the managers. A big hurdle to Model L, at least in California, and at least for the moment, is that the LLC is not exempt from the California franchise tax or the annual LLC fee, even though it's wholly owned by a charity. In addition, as I alluded before, the LLC has fundamental connotations of for-profit business, and in fact, some of the interest we've seen in Model L has come from people who think it's meant for business ventures with outside investors, when in fact the fiscal sponsorship setting restricts this concept to purely charitable purposes. So, some final thoughts on Model L. We think there's a chance that Model L could become the dominant model where risk management is a big concern, or at least enough of a concern that it would outweigh the cost and effort of establishing a Model L structure. Of course, even wider use may be possible if the issue of state and local taxes could be resolved. In more ordinary cases, though, we think that models A and C are relatively simple and straightforward, and they may remain the preferred choices. For more background on this concept, I'd refer you to one of the handouts for our presentation, which is the article where Greg and I originally fleshed out Model L. It's called The Use of LLCs in Fiscal Sponsorship, a New Model.